James. Yeah, have you sent the sitting ID to the claimant? It's not online.
May it please this honorable court?
You can't announce appearance while hiding your face. You have to show your face for me to record you.
As court pleases. Apologies, my lord.
You have to on your camera. Yes.
May it please this honorable court?
Yes.
Katie Jibril for the claimant.
Yes.
Katie Jibril.
K-T.
Jibril. Jibril is spelled J-I-B-R-I-L. For the claimant, my lord.
Okay. This matter is for judgment. The judgment is ready. It will be read out shortly. This is the judgment of the court. The case of the claimant as can be gathered from the general form of complaint filed at the registry of the court on 19th day of September 2024. The pleadings and witness statement on all is that she applied for employment into the civil service of Cross River State in year 2022 for the position of State Counsel in the Ministry of Justice. Following the advert, the claimant was, after being interviewed, given an offer letter, which the claimant accepted by going through the processes of documentation at Cross River State Ministry of Establishment, and was further issued appointment letter which placed the claimant on grade level 10, step 2, and was asked to come for documentation, which the claimant complied with by taking all her documents, all required documents to be admitted, and was asked to pay an unrestricted sum of 4,500 naira. The claimant stated that during the documentation, claimant inquired of where and when she was to resume. The director admin informed the claimant that a message would be sent across for induction, after which claimant would be posted. It was not only the claimant that applied, there were others who also applied and were given appointment letters who also documented in Ministry of Justice. The claimant has not received her salary as contained in the appointment letter, The claimant advised that 13 persons who were among those interviewed and received appointment letters through the same process with the claimant are already posted and being paid. The claimant and others who were not posted wrote to the second defendant to ascertain the rationale for the discrimination of the posting as they were not being posted along with those who were interviewed and employed together with. The claimant employment is running as the same is covered by civil service rules, and the claimant appointment has not been terminated. The claimant has been going to the second defendant office and has been removed at each occasion at each occasion. Whenever she goes to the office from her hometown, which is more than 50 kilometers away from Calabar, the second defendant has refused to address the issues raised by the claimant since when the letter was served on him. This prompted the claimant and others to write a letter to the governor or the first defendant appealing for audience, posting, and to payroll. The first defendant refused to attend to the letter of claimant, and the claimant and others did a reminder via courier, which was delivered. However, no response was received. The claimant also stated that she cannot practice as a barrister and solicitor called to the Nigerian bar pursuant to the Provision of Legal Practitioners Act. She is still under the employment of the defendant as state counsel. The claimant has been paying her practicing fees for the past 2 years, but due to the action of the defendant has not been able to apply for her complementary seal due to the constraint caused by the defendant, and this has greatly inhibited her practice. Based on the appointment letter the claimant issued issued by the third defendant, the claimant was placed on grade level 10, step 2, with a annual salary of 2,343,789 naira 96 kobo. The claimant, as a result of the refusal of the defendant to respond to the claimant, the claimant engaged the services of Daniel I.G. Ahiako and Ahiako Good Name Chambers, a law firm of legal practitioners, tax consultant, and notary public of number 38 Port Harcourt International Airport Road, Omuduku, Igurutu, River State, who charged the sum of 3 million naira as cost of litigation. Based on the above stated fact, the claimant by this complaint is claiming for the following reliefs. 1, a declaration that by this honorable court that the claimant is a staff of Cross River State government and that her appointment is statutorily provided for. A declaration that the claimant is entitled to be paid monthly salary as contained in the appointment letter. 3, the sum of 4,296,948 naira 26 kobo, being salary from 2022 to 2024 at annual salary of 2,343,789 naira 96 kobo. 4, an order of this honorable court mandating the first defendant to deploy the claimant to her duty post. 5, the sum of 20 million naira as special cost of litigation and general damages for the year the defendant has made the claimant to redundant. 6, 21% post-judgment interest. A reaction to the claim of the claimant, the defendants with the leave of court filed their statement of defense out of time wherein they denied the claim of the claimant. It is the case of the defendant that the second defendant never put up any advertisement or vacancies for state counsel, as it is not the ministry charged with the responsibility, but admitted that the claimant was issued a letter of offer and a letter of appointment without more. The defendant also admitted that the claimant was not posted. In response to paragraphs 11 to 24 of the statement of facts and in answer thereto, the defendant stated as follows that the recruitment process conducted by the third to fifth defendants into the Cross River State Civil Service in the period the claimant was employed was marred with abnormal, egregious, and unbelievable irregularities. The said irregularities were so grievous that the employment process could not be followed through, even though appointment letters had been issued. The defendants therefore had to investigate the irregularities. The investigation revealed, among other things, that several persons had been recruited without the prerequisite examination. In the case of law officers, the examination is usually set and supervised by the management of the Ministry of Justice, who also make up of the interview panel. Although the said exam and interview is conducted by the post-dependent, i.e. the Civil Service Commission, the Ministry of Justice did not set or supervise any such examination nor partake in any such interview. The investigation also revealed that several fake appointment letters were in circulation. A staff of the post-dependent had been found to be connected with these unbelievable irregularities, which she achieved by falsifying claimant's signature, by falsifying the chairman's signature, and using same to deceive global cross-variant. The post-dependent therefore circulated a request to retrieve such fake appointment letters. At the time of circulating the letter of retrieval, about 81 fake letters had been issued by the culprit. While the said investigation was ongoing, more appointment letters already issued were found to be fake. The post-dependent therefore had no choice than to issue a disclaimer and a directive to all ministries, departments, and agencies of the first dependent to isolate such letters and withdraw them from circulation. The interest of the state and to prevent the situation where all kinds of unverified persons were dragged into the civil service through the irregular process. The defendant had no choice but to suspend the employment process until every existing civil servant or recruited had been verified. The information was circulated to the public via press release dated June 6, 2023. The then chairman of the post-dependent, Mr. Uko Inaku, under whose supervision the said irregularities took place, was removed and replaced with the current chairman. The staff of the post-dependent who had been found to be connected with the said fake letters of appointment was petitioned to the police and investigated. Following the conclusion of the said investigation by the police, the disciplinary process of the post-dependent, the appointment of the said staff was to whom the issuance of the said fake letters was connected was terminated. The defendants stated that the claimant's appointment was inadequate, that the claimant was not posted, her services were not engaged for a single day, nor did the claimant work for a single day to entitle her to her salary. In answer to paragraphs 11, 12, and 13 of the defendant stated that the employment into the civil service is not complete by mere issuance of appointment letters without more. There must be employee verification and image capturing, payrolling, induction, and posting to a department where the skills of the employee must be put to use before the payment of salaries due to the internal investigation and verification of recruited process. None of this completion process took place in the case of the claimant. Further and specific response to paragraph 13 to 14, the claimant is being economical with the truth or recruits as the State Council were invited to the Ministry of Justice for verification exercise. Because of the seriousness of the situation, the warning by the post-dependent to all MDAs about fake appointment letters in circulation and avoid foul play, the said verification exercise was personally conducted by the second dependent, i.e. the Attorney General Commissioner for Justice, on 11th day of September 2023. The claimant never presented herself for the self-verification exercise, which information was well circulated and the claimant was aware of it. All recruits who turned up for the verification exercise and whose appointment were verified were absorbed into the state civil service and posted in the case of the Ministry of Justice. Certain recruits referred to in paragraph 13 of the claimant's claim were verified, posted, and are earning their salary for work done. It was after the said verification exercise and subsequent posting that the claimant and some persons having similar situation wrote to the second dependent, further distorting the truth by also stating because they do not stay in Calabar metropolis, they asked their colleagues to represent them. The dependent denied paragraphs 12, 15, and 22 of the claimant's claim, and in answer to that, the claim stated that the claimant is not entitled to payment of any salaries as her employment with the dependent is yet running and her inadequate recruitment process was not completed. The claimant's failure to participate in the verification exercise resulted in the automatic forfeiture of her appointment. Paragraphs 16, 17, 18 are denied. The dependent have no knowledge, nor receive any letters from the claimant. After Exhibit 3, paragraphs 19 and 20 are denied. The dependents have in no way prevented or stopped the claimant, who is not their employee, from practicing law as a barrister and solicitor in Nigeria, or from applying for her complementary seat. The dependent further stated that the claimant who did not turn up for the verification exercise did not resume for a single day or work for a single day is not entitled is not in the employment of the dependent and is not entitled to any monthly salary. The dependents shall urge this court to dismiss the claimant case. Upon being served with the statement of defense, the claimant filed a reply to the statement of defense, wherein more insight were given as to her case. For to save time, I shall skip reading the reply. The submission of the defendant formulated a single issue. I will skip reading I have captured the argument in the body of the judgment. The claimant formulated 12 issues. The arguments on the issues have been captured in the body of the judgment. So I will go straight to the decision of the court. I have considered the processes filed by the parties. In this case, the evidence adduced in proof of respective positions of the parties, as well as written and oral submissions of counsel for the parties. It appears the gem we are using as having problems, so you can remove your wig and gown if you so wish because of the heat. Hey, what happened to the gem? Huh? From the fact as disclosed by the pleading and evidence before the court, the grounds of the claimant is that in year 2022, the Cross River State government published vacancies in various ministries in the state requesting individuals interested to apply. Consequently, claimant applied and was issued with offer of appointment Exhibit A by the post dependent. The claimant accepted the offer and did documentation at the Ministry of Establishment, and appointment letters were issued to the claimant. See Exhibit A, B, C, A, B, and C. In May 2023, at the Ministry of Justice, the claimant did documentation by submitting her documents at the registry of the ministry, and upon they will get in touch with her for payroll, induction, and posting. In September 2023, representative of the newly recruited staff of the Ministry of Justice visited the Attorney General, but the topic of their employment was swept under the carpet. Thereafter, the claimant and others who were not in attendance as the visit tried separately to visit the Attorney General, but all attempts proved abortive. They also wrote to the governor, but no response. The dependents on their part, while placing reliance on Exhibit D1 to D6, stated that the appointment of the claimant was marked by irregularities, as 81 letters of appointment were forged or found to be fake and issued without the person or authority of the fourth dependent. As a result of the discovery of the irregularities in the process of recruitment by a fourth dependent, and in an effort to rectify the lapses with a view to having employees with genuine letters into the service, the process was suspended and candidates were directed to attend verification exercise at the second defendant's office, but the claimant failed and refused to attend the verification exercise. That's why she was not verified and was not among the 13 employees verified, payroll and posted, and are now enjoying their salaries. What emerged from the facts of this case are that the recruitment exercise was conducted by the first defendant, which resulted in issuance of appointment letters to several individuals, some of whom have been successfully paroled. The claimant was one of the candidates issued the letter of appointment into the civil service by the post defendant. However, she is yet to be paroled and yet to be paid any salary by the defendant from 2022 when she was engaged up to 2022 when this matter was filed before the court. The claimant instituted this action to seek for declaration that she is a staff of Cross River State Government and that her appointment is statutorily provided. She is also seeking for declaration that she is entitled to be paid her monthly salary as contained in the appointment letter in the appointment letter, and also she is entitled to arrears of salary in the sum of 4,296,948 naira 26 kobo. She also seeks for an order mandating the defendant to deploy the claimant to her duty post and 20 million naira cost of litigation and general damages. She also claimed 22 of the view that the claimant has failed to discharge the prudential burden of proof required to be entitled to relief sought. They also asserted that the procedure for recruitment of staff into Cross River State Civil Service was not followed due to the fundamental improprieties surrounding the procedure and the issuance of appointment letters, particularly the fake appointment letters in circulation. It was the business of the defendant to verify the letters in circulation. Hence, the verification exercise which the claimant deliberately failed to attend, as the claimant built her case on lies that the job was advertised and that she applied for the job and was interviewed, and that she wrote Exhibit D to the defendant to challenge the discrimination in employment employing her colleagues, whereas there is nothing in Exhibit D to that effect. That she has been unable to practice law, whereas her professional details, as shown by Exhibit D7, says difference. The claimant who has not earned salary is not entitled to be paid monthly salary arrears or any other benefit at all. Claimant cannot claim or recover solicitor's fee as general damages. It is right that in civil matters like the one at hand, the duty of court is to determine cases based on the facts established at the trial. As such, fact constitutes the fountainhead of the law, and decision or determination of the cases are related to the facts of and each case is considered on its own factual meaning. The facts cannot be. Thus, the court has The court has thus, the address of counsel cannot be a substitute to the facts or evidence. Therefore, for the claimant to succeed, must to supply sufficient credible evidence in proof of her case. See the case of Asumere versus Ane by section 131 to 132 of the Evidence Act as amended. Whoever desires any court to give judgment as to the legal right or liability dependent on existence of facts which he asserts shall prove that those facts exist. Similarly, in civil cases like the one I had, the burden of first proving existence or non-existence of fact lies on the party against whom judgment of the court would be given if no evidence were produced on either side. It is a requirement of the law that it is a requirement of the law which stands as legal burden. In this case, the claimant who wants this court to give judgment in her favor is the one that has the legal burden to prove the assertions made by her to entitle her to judgment. See the case of Okoro versus Ode. See also the case of Onwuka versus Ediala, Dibiaka versus Osakwe. Now, from the facts and evidence before the court, has the claimant been able to discharge the legal burden of proof imposed on her by law to be entitled to grant of any of the relief sought? The claimant rely heavily on Exhibit A, B, and C in proof of her assertion that she has an employment having statutory payable and therefore entitled to be paid salary from 2022 to 2024 when she instituted this suit. However, the defendant countered that the recruitment exercise was marked with irregularities ranging from absence of advertisement, no examination conducted, and no interview conducted. Above all, there was issue of fake letters by one of the members of staff of the post defendant, which resulted in her dismissal, termination from service as per Exhibit D5. There is also the claim that the entire case of the claimant was built on lies. There is no disputing the fact that the issuance of letters of appointment by a post defendant to claimant and acceptance of the said letter amount to establishment of a contractual relationship. This also presupposes that there is a valid contract of service. However, the presumption of regularity is a rebuttable one, with the defendant insisting that the employment of the claimant as per Exhibit A, B, and C is fraught with irregularities. The defendants have the burden of proving that the irregularities are capable of affecting the validity of the appointment of the claimant to render it illegal or illegal, invalid, null, and void. And it's entitled the claimant to make any claim based on the same employment that was bedeviled with irregularities. By the Cross River State Public Service Rules 2004, by the provisions of rules 02102 and 02007 of the Cross River State Public Service Rule 2007, vacancies to be filled by the post dependent are to be advertised to give chances to interested candidates wishing to vie for those positions or posts to apply for consideration. The rules also The rules also has provided the mode of applying for those vacancies, which is by way of filling forms in a prescribed manner by the post defendant. Thereafter, the forms will be scrutinized to confirm or to verify the claim made by the particular applicant. Thereafter, an interview will be scheduled for the candidates that wishing to vie for the post. The rules also the claimant has, in her statement of facts, a reply to the statement of fact, insisted that there was advertisement and it was based on the advertisement that she applied. She was interviewed and exhibit A, B, and C were issued to her. The law is well settled that where parties have joint issues, the claimant must to prove those assertions with credible evidence. Apart from ipse dixit, the claimant has not adduced any evidence to support her claim that advertisement was made, with the denial by the defendant of making any advertisement. The claimant has a duty to establish that advertisement was really made and also interview conducted. But the claimant has not adduced any evidence in support of her claim. She has stated that the advertisement was made on website and also on print media. The claimant therefore has a duty to adduce evidence to show the website where the advertisement was made, and also to tender copies of those advertisements that were made in the print media. She has not done any of those. In the absence of proof of advertisement and conduct of interview, I reject the assertion of the claimant that there was an advertisement and interviews for the recruitment exercise as per Exhibit A, B, and C. The Public Service Rules 2004 forbid appointment without advert and interview. That the contract was tainted with misrepresentation when the claimant pleaded that she complied with all the conditions precedent to be employed, which the court found to be false. The claimant has stated that she wrote an application while the rules required filling of an application. This goes to show to support or corroborate the claim of the defendant that the claimant built her case on lies. However, let me quickly state that advertisement and interviews are pre-employment irregularities, which, if there is no evidence of non-involvement of the claimant, may not have any negative impact on the recruitment exercise. But in the case at hand, The claimant insisted there was advertisement and that there was also interview, and she partook in the interview and letter was issued to her. However, the finding of the court is contrary to the assertions of the claimant. This means the defendant has succeeded in proving that claimant lied regarding the claim that she put before the court concerning the pre-employment irregularities. In the circumstances, the claimant should not be allowed to benefit from her own wrong. One other disturbing aspect about Exhibit A, B, and C is that the offer of appointment was said to have been made on the 4th of November 2022, while the offer of appointment to pensionable establishment was issued on the 20th day of December 2022, and the mail letter of appointment was also issued on the 20th day of December 2022. Exhibit B requires that the acceptance of the offer of appointment made as per Exhibit B, which was issued on the 20th day of December 2022, must be done on the 4th of December 2022, while Exhibit C clearly shows that the said acceptance was done on the 19th day of December 2022. In the circumstances, it means that there was no acceptance of the offer of appointment by the claimant, as it is not in line with Exhibit B, which says that the said acceptance must be done on or before the 4th of December 2022, while the acceptance was clearly shown to have been done on the 19th day of December. In the circumstances, the claimant has not accepted any offer of appointment. In the circumstances, she had no employment at all. The foregoing analysis cast doubt on the legality of claimant's appointment. The claimant would have been vindicated on her claim that she underwent formal interviews by relying on the Indo management rules, which means that she is not expected to know the internal administrative lapses of the commission, but no such interview took place. This goes to show that the claimant has knowledge of the pre-employment irregularities regarding lack of advertisement and interview, though failure to is the dependent doings and not the claimant. The claimant cannot be absolved from blame since she falsely stated there was an advertisement and interview when in fact there was no such advertisement and there was no such interview. Could have held that if an irregularity was fault of the employer, the innocent candidate should not be punished for those internal failures. However, in the case at hand, the claimant, as shown above, cannot be absolved from such. Another issue regarding the validity of claimant's employment borders on verification conducted by the Attorney General, which the claimant failed to attend. The question that need answer is, can refusal to attend be shaped or impact negatively on employment of claimant? The claimant insisted in exercise on the face of the denial, but on the face of the denial of being notified or invited to attend the said verification exercise, the onus is now cast on the defendant to prove that the claimant was indeed notified of the verification exercise, but failed and neglected to attend. The defendant insisted, instead of bringing evidence of invitation extended to the claimant to attend the verification exercise, placed reliance on Exhibit D as evidence of claimant's knowledge of the exercise. I have scrutinized Exhibit D. There is nothing in it to indicate claimant's awareness or knowledge of verification exercise conducted by the second defendant to ascertain the genuineness of employment of new employees recruited by the first defendant in disregard of extant rules and regulations and racketeering scam shown in the employment process. See Exhibit D1, D2, D3, and D4. In view of lack of proof of claimant's invitation, the failure to attend does not attract any negative consequences. Furthermore, the Attorney General does not typically have direct statutory power for involvement in matters of employment handled by the first defendant. However, his role in a verification exercise is often administrative or investigative. This is because the Attorney General is the chief officer of the state and can be directed by the state chief executive to lead a committee or panel of investigation to investigate administrative irregularities, while the Civil Service Commission has the exclusive constitutional power to appoint and discipline the executive arm and discipline the employees in the state. What is clear is that the Attorney General cannot unilaterally discipline a civil servant. He can only recommend actions to Civil Service Commission of Governor based on his finding. Therefore, the verification conducted does not have any impact on employment conducted by the first defendant. Therefore, failure to attend such verification may only raise a presumption that the appointment is fake or that the officer is deliberately staying away to avoid detection. However, in the case at hand, the claimant was not notified or invited to attend that verification exercise. So the failure to attend verification exercise cannot amount to forfeiture of appointment. However, having found that the Exhibit ABCD attended with irregularities, the finding on verification will not have any impact on those exhibits. I now turn to the claim of arrears of salary and entitlement to be paid as and when due. It is only upon the existence of a valid contract of employment that the employee or employer can rely on terms and conditions of contract of employment as binding on parties. In the instant case, the court found that there is no binding enforceable contract of service, as there was no valid acceptance of the said employment as laid down by the rules, and also there are some pre-employment irregularities that also tainted those exhibits with This means no claim can be entertained on salary due to absence of valid employment. Another cloak to the claim for salary was the fact that the claimant, even if she has a valid letter of employment which is disputed, she cannot ground claim on salary, as by the admission of the claimant in her statement of fact, she is yet to resume duty. The claimant has also not served the dependent for 1 day. In Honica Sawmill Nigeria Limited by Sishoff, it was held that as between the employer and the employee, the onus is for the employee to prove that the employer employed him on a stipulated salary and that he worked for the employer during the relevant period. And it is for the employer to prove not only that he paid for the employee his salary for work done by the employee in the relevant period, but also how much the salary was that was paid to the employee by the employer. In the instant case, the claimant did not prove to this court that she worked for the employer during the relevant period of the claim. The claimant is accordingly not entitled to any arrears of salaries. The claimant is accordingly not entitled to any arrears of salary as claim in her complaint. I so find and hold. The assertion of the claimant that since her employment in 2022, she has not been paid salary has no basis because the claimant is yet to complete her employment procedures or processes as she has not resumed in the public service rules. In the public service, date of resumption of duty is taken very seriously, and it is what determines when an employee starts to earn his salary. The claimant having admitted that she has not resumed, therefore she cannot claim entitlement to any salaries when she has not even started working for the defendant. It is only upon the existence of a valid contract or employment that an employee or employer can rely on the terms and the conditions of the contract as binding on the parties to make any claim in respect of that employment. In the instant case where there is no valid binding and enforceable contract of employment, the claimant has no locus to claim arrears of salary not earned as she has not worked for the defendant to be entitled to such salary. From all I have been saying above, the claimant has not proved entitlement to declarations sought, which are the main reliefs, and the failure of the declaration means failure of all the other ancillary or incidental reliefs sought by the claimant. All in all, the case of the claimant willfully failed and same is hereby dismissed. I make no order as to cause parties to bear their respective costs. Judgment is hereby entered accordingly. Call the next case.
And Equal Nigeria Limited. And the parties are active.
Appearance. Yes. Emmanuel Sani. Are you appearing for who? Appellant. You appear with who? Yes. Any other appearance? Yes. Some on